world where the rule of law, not the law of the jungle, governs the conduct of nations.
If you're looking for the real help, babybar.online.
Hello everybody, this is the BP Learned Hand with FYLSC Real Help to Pass the Baby Bar. This is going to be part 2 of our 3-part series on defamation. As you can see, we will be covering another essay. This essay, just like the other one, does include other theories, but we will solely be focusing on the defamation aspect. So sit back, pull out your essays, get out your rule statements, and let's go over this and let's get it all done. So we did this video a little bit differently based on some of the feedback I'd received. As you can see, on the left-hand side of the screen, I have the fact pattern up, and on the right-hand side of the screen, I have my essay where I'm writing my essay. There's 3 calls to this question. So what I'm going to do on my outlining area, or where I'm going to write my essay, is I'm just going to immediately go ahead and I'm going to throw down the calls. So Ned v. Carl, Carl v. Ned, and then the homeowners versus the supermarket. Then what I do is I go over to the left side and I begin issue spotting. The way I did this video is I did it without sound, and I am going to speed it up. I'm going to go through the issue spotting, and then I'm going to start fleshing out my essay. It did take me 12 minutes to issue spot and to outline my essay, and there are other theories involved in this essay. What I want to do, though, is I want to focus on defamation. Since lots of us, most of us, don't have time to sit here and watch somebody issue spot and then outline an essay, what I'm going to do is I'm going to speed it up for you. But I will also make it available on the website on babybar.online, so you can watch it in real time and watch the slow and grueling process of identifying your theories, putting them where they belong in your essay, and then, you know, putting down rule statements. I did outline all of the issues, and I did throw down rule statements for all of the issues, so you should be able to see that. I have been told the video is a bit fuzzy. That should not be a problem, because I will make my Word versions of these available to you as well, so you can download them and have them in front of you. So without further ado, I am going to go ahead and I am going to fast forward this video so we can actually get into defamation and into the nitty-gritty of this. All right, here we go. Let's let the video magic happen. So now that the fast forwarding magic has been completed, if you'll notice on the left hand side of the screen I have the fact pattern, and on the right hand side of the screen I have the essay which we have outlined. As you can see, I did add all of the elements and all the theories I found. One thing that I left and that I wanted to point out to everybody is, if you'll notice, under my IIED, I have defenses to IIED, and then I have a bunch of question marks, and I put, I see none, come back. Well, the calls to the question specifically ask you what claims they can bring and what defenses the other can bring. So I identified IIED, but I wasn't sure what defenses I initially saw off the bat. And since it's very much as a racehorse question, I just put a bunch of question marks there. I know I have to come back to it. I know it's something I'm going to need to look at, but I just right now in my head at this moment think I do not have the time. I need to get through, I need to outline, and I need to get my rule statements down. As you can see, that's kind of also the same for homeowner versus superstore. I do have negligence here, and then I have a bunch of the elements to the prima facie case down, and then some of the other placeholders that I commonly use, but I haven't fleshed it out yet. This is a very common thing when you're working with time management in your essays that you're going to have to pay attention to. So what you're going to want to do is you're going to want to put down what you can, and then, for instance, if you didn't see that IIED defense, then you're going to put question mark there. You're going to go through, you're going to do what you can do, and then you're going to stop, and then you're going to spend the time to really think about the stuff that just doesn't pop into your head immediately. So in this specific fact pattern, we're going to focus on defamation, and defamation is kind of in the middle of everything. The funny thing about defamation is, if you look in the fact pattern, one of the things that you'll notice is that Ned published an account of the incident. It is this one tiny sentence that brings up this whole giant discussion. So we're going to get into our defamation discussion now. I am going to take the defamation section and I'm going to put it on its own page, and we're going to start putting it together on the outline on its own. So as you can see, I basically started a new page on the right-hand side. So let's go ahead and let's start with defamation. We know that we have our rule statement here. We have a defamatory statement of and concerning the plaintiff published to a third party with scienter, which causes harm to the defendant. So let's go ahead and let's throw our rule statements. Let's break this rule statement into elements, and then our elements into more rule statements. So we're going to have a defamatory statement, right, of and concerning the plaintiff, published to a third party. And then this is where you're going to really want to distinguish between whether you're talking in common law versus the new modern majority, which brings into constitutional issues. So the way I outline it, and it may be different depending on what school you go to, is I do my defamatory statement of and concerning the plaintiff, published to a third party, and then the last part of that I do is I go ahead and I do damages. So what I will do is I will go ahead and I'll take all this and I will underline it. This saves me time, so when I'm going through and I start writing out my rule statements, I don't have to underline again, and it saves me time. So let's get our defamatory statement down here. So if it lowers the plaintiff in the esteem of the community or discourages third persons from associating with him. So I know that a lot of you right now are thinking, okay, don't you have to show that it was understood as that? Well, of and concerning the plaintiff is where we kind of had that discussion. Here we need to bring up the defamatory nature. So a message is defamatory if it lowers the plaintiff in the esteem of the community or discourages third persons from associating with him. So this is where we're going to want to have our discussion, where Ned published an account of the incident calling Carl a coward and a liar. So this is where we'll have this. Of and concerning the plaintiff. Now, this is where everybody, I've had a few questions about this. This is where you're going to want to put the basics of your plaintiff knowing rule statement, basically. So let's go ahead and put this here. must prove that a reasonable third person who received the defamatory message understood it to refer to the plaintiff. So basically, this is that part of your analysis where you're going to show that the person who received it, which would be the audience of the newspaper, understood it to refer to the plaintiff. It doesn't mean that they believed it. It just means that the reaction was a rational one and that they knew what it meant. So here in our fact pattern, what we're told is that Ned published an account of the incident calling Carl a coward and a liar. Well, being called a liar is definitely a defamatory statement, right? It lowers your esteem in the community. So that is where that discussion is. If the newspaper would have called him, I don't know, like a two-branched elm tree, now that would be the discussion that you would be having in the defamatory statement, showing that nobody would ever read that kind of thing and see it as defamatory, even understand it maybe. So really pay attention to the specifics of it. Since you have a single basically two sentences, that's all you have to work with. You have to really pay attention to what those two sentences are talking about. So now we're going to go into our published to a third party. The defendant's message concerning the plaintiff must be communicated to a third person who understands and receives it. So depending on the fact situation that you're going to be in, and this is not one of those fact situations. Remember, if you're going to have eavesdroppers, you have to look at the surrounding circumstances, because if you're in your home and you have a reasonable expectation of privacy, then that's going to change whether or not, this is published. If, for example, you have a statement that is being made inside a restaurant where somebody is, whispering, then what you're going to have to bring up is that there is no reasonable expectation of privacy in a restaurant. The other thing that you're going to have to bring up is the fact that, if the defendant negligently permitted it to be communicated to third persons. So if you are in that restaurant and instead of whispering and being careful, you just say it real loud. I think we all saw on the news a story recently about some attorneys going to a restaurant and having a very candid conversation in the middle of a restaurant, and there being an eavesdropper. Well, remember, you have no reasonable expectation of. Now, damages is where I really wanted to spend some time today, because when I was going through my 1L, we didn't spend a lot of time in tort damages, and I've had this mentioned to me by quite a few people. So when you're looking at defamation and you're looking at your damages, there's basically three types of damages that you really need to be looking at. You need to be looking at your pecuniary, PECUNIAR, pecuniary damages. You need to be looking at your presumed/general damages, and then you need to be looking at your punitive damages. And these are the three types of damage discussions that you're going to want to have. Now, they're not all applicable. There are certain things that you need to show. Of course, they're all their little special snowflake damages. So here with our pecuniary damages, these are quantifiable monetary losses suffered by the plaintiff due to the injury to her reputation, or his reputation in this case, I guess. And these kind of damages are things like, you have a loss of customers, a loss of job, any other diminishment in your economic advantage. Here we're told that Carl experienced a substantial decrease in business consulting. And so pecuniary damages specifically speak to this. This is that, a quantifiable monetary loss due to the injury to his reputation. So in order for Carl to be able to recover on pecuniary damages, the plaintiff must present evidence of specific actual monetary losses. So let's go ahead and let's get this down here. Plaintiff must present evidence of specific actual monetary losses in order to recover pecuniary damages. So next we have our presumed or general damages. In certain circumstances, the jury, remember this is important, the jury is permitted to presume the plaintiff suffered general damages as a result. Now, these include the non-pecuniary aspects of the injury. So humiliation, loss of friends, embarrassment. The jury is instructed to estimate the amount of presumed damages based upon the extent of the injury to the plaintiff's reputation. Something along the lines of, in certain circumstances, the jury is allowed to, let's see, to permit general damages other than pecuniary damages that result in injury to reputation. The jury is instructed to estimate the amount of presumed damages based on the extent of injury to the plaintiff's reputation. So this is where you'll have your discussion about, you know, I mean, this is pretty extensive, having this placed into a newspaper. That, I mean, that's more than just a little bit here and there. And depending on the size of the town, I mean, this could be a lifelong injury where, you know, for the rest of his life, he may be the guy in the newspaper. So that's where you're going to want to have that discussion. And then finally is punitive damages. And, you know, punitive damage are generally made for punishment to deter future wrongdoing. And plaintiff is going to have to make some additional evidentiary showing of basically the malice to recover. So they're going to have to show like an evil intent, that they did this on purpose, that they were going to get this guy. And I think a really good argument could be made in this situation where, you know, you have Ned, who clearly, you know, runs a newspaper, writes all this stuff, and he publishes this because he's mad at Carl. So, I mean, I think you have a really good argument there. So let's go ahead and let's get this rule statement down here. Against the defendant to punish and deter future wrongful conduct. Now, I can't think of a better place than to want to deter future wrongful conduct than somebody who, you know, is known for publishing and, you know, publishes these types of things and has the potential to publish them in the future. So let's see. Let's make sure I can at least spell the word. Against the defendant. Okay. So the other thing that we have to look into is we have to look at when presumed damages are available. So it's presumed the plaintiff suffered general damages, and that's up here in this presumed general damages. It's just presumed that they suffered these general damages, and no actual proof of harm is needed when the form of defamation is slander per se or ordinary libel. So in order for us, this is very similar to finding the degree of murder. In order for us to assess the damages, we have to assess the type of defamation. So let's get into our slander v. libel conversation. So libel, L-I-B-E-L, at common law was a written defamation. Modernly, a defamatory message embodied in any relatively permanent form is libel. Slander, common law, was defamation which was spoken, and modernly defamatory message not preserved in permanent form. So we do have a little bit of, a modern versus a common law majority, but I think that that's just because they didn't have the internet. We have the internet now, so it's a little bit different. So remember, when you're looking at slander and libel, you always want to look at slander per se. You also have your libel per quad. Now your libel per quad, which is not apparent on the face of the communication that's defamatory. So the plaintiff has to plead extrinsic evidence and facts and stuff to show that this was a defamatory message, basically. A large minority of the jurisdictions require proof of special damages when it's in libel per quad. Now what we're going to want to do is we're going to want to make our determination on what this is. And we're going to want to put this down as libel, because remember, slander spoken and libel is clearly written. So one of the things that I hear from a lot of people is they have a hard time on getting into the constitutional issues when you're in a defamation type discussion. And so one of the statements that I've always just kind of memorized and I've always used in defamation, I will use constitutional issues as my heading, and then I automatically go into, this set sentence that I have that helps me make my essay feels like it flows a little better. So what I do is I do that the First Amendment to the Constitution has altered the common law of defamation with regard to the degree of fault required and the burden of proving falsity of the defamatory statement and the potential presumed and punitive damages. Now this is one of those sentences that's kind of my roadmap, and it's also my lead-in sentence. I still have that really bad habit of feeling, since I'm an English person, that all of my essays have to flow and they all have to make sense. So this helps me. This sentence helps me feel like I'm clearly addressing the constitutional issue and I'm telling them what I'm going to be discussing when I get into this. So, the degree of fault definitely changes in these constitutional issues, because at common law, defamation is a strict liability offense, right? So they only needed to establish that the statement was made, and then, they would recover. They didn't need to show any mental state, right? But we all know that now, based on whether we find the plaintiff as a public official or a public figure, whether this be a matter of public concern, that changes that, right? So here, the next thing that we're going to get into is we're going to get into the nature of our plaintiff, right? Because this is really going to make a big difference as to, once you get into, just like you do when you're doing homicides, once you get into that degree analysis, where we're going to go with our damages. So we're really going to want to discuss the nature of this plaintiff. So New York Times Malice says that when the plaintiff is a public official or public figure, plaintiff must establish that the defendant acted with malice before he can recover. So here we have Ned publishing this about Carl, and we're told that Carl is a business consultant, and I do not see a very strong argument for a business consultant being any type of public official or public figure, depending on what type of business consultant. I don't see this being any kind of public anything. So we're just going to put our rule statement down. This is one of those issues where you're going to bring it up and you're just going to get rid of it real quick. So let's make sure we're not underlining as we go. Where the plaintiff is a public official or public figure, plaintiff must establish that defendant acted with malice before any recovery may be had. you know, here it's going to be pretty easy because all you're going to have to do in your here because therefore statement is that, you know, clearly this guy is just a business consultant. He's he's not a public official. He's not, so the showing of malice is not required here. So here, you know, you'll have your analysis on that. You'll do your, you know, whether or not this was of a matter of public concern, which it's not. And then you'll say, you know, here, this is a private person. The subject matter is private and not a matter of public concern. Common law defamation applies without constitutional modification. So here what we're going to do is we're just going to put down our presumed general damages, and then we're going to do see above. Presumed / general damages, and we're going to do see above. You can say supra, you can say see discussion above. It's whatever you want to do. Because remember, general damages can be presumed under defamation, and punitive damages awarded after proper proof if the plaintiff can show that there was New York malice or where the common law applied. And because we didn't have to show malice, common law applied, so our damages discussion, we would just do see above, right? We wouldn't need to get into any of that. So now we're going to get into our common law privileges and defenses. So here we have truth. We know that a majority of jurisdictions regard proof that the defamatory message was true is a complete defense. So truth is a complete defense, even though there are some minority jurisdictions that do say, depending on whether there was malice or not, that could change the outcome. But we want to stick with common law, and we want to stick with the modern majority. So we're going to go ahead and we're going to throw our rule statement down here on truth, and we're going to put that majority of jurisdictions regard proof that a defamatory message was true as a complete defense to a defamation action. So we know that next for absolute privileges, we have absolute privileges when we have our legislative proceedings, our judicial proceedings, our executive communications, things that happen between spouses, when you're compelled by the law. And we know that the burden of proof for those is that the defendant has the burden of proving that absolute privilege. Well, we know this guy doesn't have any type of absolute privilege, but he may have another type of privilege. He may have qualified privilege, right? So we need to look at our qualified privilege. We need to think to ourselves, do any of the elements of a qualified privilege apply here? So that's just what I see. So I'm not going to bring up a privilege because I don't see anything. And then consent. We all know what consent is, and consent is one of those defenses to defamation. Now, I don't see consent anywhere in here, but I did want to put it down so that you would all remember that it is a potential defense to a defamation claim. So now that you've got all this out, all you have to do is put in your here because therefore statements and flesh this out. Make sure that you're, clearly communicating your analysis, and you're done. So that wraps it up for us. I'm going to go ahead and slap this down, and I will talk with you later. Don't defame anybody.